Trump's dismissal motherlode part 2. We've got a whole slew of filings from the president's defense team, and we've already gone through his motion to dismiss based on constitutional violations. It was a 31-pager, part of a series of what we're calling 4 motions, calling them the motherlode, because they are all quite good and quite juicy. Been waiting for Trump's team to assemble these for us to unpack. And so there was a whole slew of constitutional violations, things like due process under the law, things like equal protection, things like free speech, things like being able to participate in the political process, petition your government for a redress of grievances. Many reasons why Jack Smith's indictment and the DOJ's prosecution brought by Joe Biden is unconstitutional, just as applied to the Constitution. And we reviewed that in depth. But this is a whole separate category. Okay, Constitution is very important. It's the supreme law of the land. It's the root document. But there are other bases, very good bases, for dismissals, like saying that the indictment doesn't match the law. And so we are going to run through in detail the motion to dismiss based on statutory grounds, which says that Jack Smith is not in compliance with the U.S. Code. And then in our final portion of this motherlode coverage, we'll also talk about the motions to dismiss for selective and vindictive prosecution and the motion to strike all of the inflammatory, colorful language that Jack Smith dumped all over the indictment, to strike all of that. So that will be part 3, and be sure you're subscribed for that. But now let's get into the motion to dismiss, because we love these juicy motions, and this one is a 34-pager filed out of Judge Chutkan's District of Columbia courtroom. The case is Jack Smith, Joe Biden, and the deep state against Trump. This is President Trump's motion to dismiss the indictment based on statutory grounds. I know that sounds kind of boring, but it's not. It's quite good. They say, Your Honor, Judge Chutkan, targeting an audience other than this court, Jack Smith's indictment in this matter rants endlessly about President Trump's politics, and in a shockingly un-American display of authoritarianism, the indictment accuses Trump of crimes for having and expressing, quote, the wrong opinions. Buried at the end of this diatribe in the indictment are conclusory statements that Trump's alleged actions somehow violated these various U.S. codes. And remember, in the law, things have to be very specific. Like, if you're going to get charged with the crime, you got to be very articulate about what the elements of that crime are. Otherwise, you could be prosecuted for anything. And so they're going to walk us through the U.S. law for each one of these sections, and we're going to unpack them. They say, Your Honor, Chutkan, Jack Smith does not explain how President Trump violated any of these statutes. All they do is simply say that he has, while regurgitating the statutory language. They're not walking us through the law. Now, as explained herein, the reason the prosecution employed this little tactic is plain. It's because President Trump did not violate the statutes, even if you accept that their false allegations are true. Now, this is a very important point. You can even say, if everything that Jack Smith said was true, every single criminal allegation was true, it still doesn't break the law, because the law does not criminalize that conduct. They say, Chutkan, accordingly, your court should dismiss this case for failure to state an offense. They complained a bunch of whining, Jack Smith, insurrection, American democracy, blah, blah, blah. But it is not criminal, they tell us. President Trump denies the allegations in the indictment and explains accordingly. The first statute that they bring up is 18 U.S. Code 371. They say the first count charges Trump with conspiracy to defraud the country. And the actual charge says the following: if 2 or more people conspire to, quote, defraud the United States, they've got that italicized for us, or any agency, each shall be imprisoned. Now, the statute that they charged Trump under doesn't tell us what that means. What does defraud the United States mean? What does that mean specifically? And it doesn't give us any textual guidance about what that means either. So at the bare minimum, however, the statute, the law, it requires something in there, a showing of trickery or deceit. And the indictment doesn't allege that. So for cases outside of financial fraud, for example, cases involving fraudulently obtaining money and other things, the statute also requires, so they're looking at other case law that says you got to have these other elements. You can't just say, Jack Smith, it's defraud the United States, right? How broad is that? What the heck does that mean? So they apply it to other types of laws. Well, if it's financial crime, it involves fraudulently obtaining money or property, or a showing of obstruction or interference. Okay, it's not as broad as defraud. Not as broad as defraud. A conspiracy to defraud the United States, it requires more. What does it require? The Supreme Court says the word defraud means deceit or trickery. And they give us another example. There was this other case. The government charged political activists who opposed the draft for allegedly defrauding the United States. They said that they printed and circulated handbills urging others to refuse to register for the draft. So prosecutors used the broad language of the statute to criminalize the disfavored viewpoints. The government said that the statute is very broad and it includes all of this. But the Supreme Court said no. You can't just charge anybody for anything. The indictment in that case was deficient because the word defraud requires deceit or trickery, not just advocacy. Okay, it's a much higher standard. They say in this case, here, Jack Smith does not allege anything that constitutes deceit or trickery. The indictment says that 3 things are needed. They say that all of these are involved in making a false statement. 1, that Trump said 2020 was rigged. 2, alternate slates of electors. And 3, making claims about Pence. All of those things Jack Smith alleges were illegal. Now they're going to take each one of those apart one by one. They say first, they say that Trump said that the outcome was tainted by fraud is essentially illegal. They say that he made the claims after meetings and in meetings with state officials, DOJ people, and all of the other people. They said that his false legal claims were problematic. But those things that he said cannot support any allegation of defrauding the United States. The supposedly false claims in Jack Smith's indictment all relate to publicly visible, vigorously disputed, widely reported debates of the day. Half the country was talking about rigged and stolen elections. Therefore, this is not at all deceit or trickery, right? In other words, the statute is for actual defrauding. Trump was engaged in just legitimate political conversation. Every official listed in the indictment unquestionably knew that election fraud and irregularities were vigorously disputed topics. Virtually every American, included cited public officials, had similar access to much of the same info. So there was no deceit. We all knew it. Many of us thought, it was fraudulent. There was wall-to-wall media coverage about this. Each official had every opportunity to form their own conclusions, just like Trump did. So how could how could he be out there? He's tweeting every day about this. Rigged, 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 rigged. They told us we couldn't even say that word anymore on YouTube. So how is Trump tricking or deceiving anyone when he's telling them exactly what he's doing? In fact, that's part of his campaign, which wasn't over, right? The campaign was to win the election. And so he's still making claims about that. How is that deceit or trickery? There's no defrauding there. It's all open. His whole timeline's filled with it. So everybody was talking about it. In fact, the Democrats were responding to it. Republicans were even denying it. There were lawsuits being filed over it. So to say that this is deceit is beyond absurd. So it is therefore entirely unsurprising that this type of conduct involving pure advocacy directed to public officials bears no resemblance to other types of cases where courts have found deceit. And they're going to give us some examples. Okay, other cases of what are actually deceit are listed there. They continue. Similarly, false statements talking about Vice President Pence are allowed. Jack Smith says that anything about Pence that's illegal, all those suffer from the same problems as well. They say, in fact, for the first time, the vice president's position had a ton of power, and then after 2020, they changed a bunch of rules and they sought to limit the vice president's duties. So they were saying Mike Pence didn't have the power, and then they took the power away that he did have after the fact, right? They closed the gap after it was over, meaning that he did have the power. Next, the indictment alleges that Trump was organizing alternate and contingent slates of electors. But the indictment does not allege any trickery or deceit in those alternate slates of electors. No, they sent them into the archives and to the courts. There's no trickery. They said, we are the alternate electors. Here's our name and signature. The indictment alleges that there was a clear difference in the form of the certified and the alternate electors, and that this difference makes them distinguishable. And they're giving us some language from the indictment, but they say that's not what the allegation is. They say alternate slates of electors were to be submitted with the understanding that they were in fact alternate electors, and then Congress would debate them. That's the point. The prosecution might think this approach was based on a baseless legal theory, but that is not a basis for fraud. They may not like the legal theory. In other words, they might disagree with the mechanics of it, but that does not constitute criminal fraud. And Jack Smith's indictment does not allege trickery or deceit anyways. They say there is no question that every relevant public official identified in the indictment fully understood which slate of electors had been certified, and no allegations in the indictment suggest that Trump attempted to cast any doubt whatsoever on this issue. Okay, Trump said, yeah, both of them came in from Arizona, from whatever state, debate them. But he didn't say that Arizona's alternate electors were actually the real ones that should be accepted and then the others thrown out, right? That's not what the indictment is alleging. Instead, the indictment alleges that President Trump attempted to persuade officials to consider alternate slates, notwithstanding any earlier certifications. Like, it wasn't an order, right? He didn't order them. It wasn't the president's calling you, accept my alternates rather than yours. Hey, debate it. Bring them up to the floor, debate the issue. This this did not involve deceit or trickery as to the electors in and of themselves, but that was protected speech about the conduct of the election itself. And so given that clearly it is no accident that this indictment doesn't allege trickery or deceit, they can't do it because the plan for alternate electors was discussed openly again. The Washington Post reported about it. They boasted publicly about it. Here's another Washington Post article. Fox News was talking about it. New York Times was talking about it. Everybody was talking about it. Now, the indictment constantly says fraudulent and fake and sham, but it uses the words fraudulent and sham to mean legally unauthorized. That is not trickery or deceit. And of course, submitting legally unauthorized alternate electors is not fraud as a matter of law, especially not to highly sophisticated public officials who've got lawyers, including the vice president and the archivist, right? So there was no fraud. Now, they say that one or more of these electors was induced to participate in the plan through false promises made. But even if this allegation were true, which it is not, they're saying Trump didn't promise anybody for anything. Even if it somehow did allege trickery or deceit, it still is not defrauding the United States as the statute requires. These allegations do not identify any supposedly misstatement to any federal official, only to other participants in the alleged scheme. That's an interesting nuance point. So basically, right, saying what they're doing is they're attacking every element of the law, right? So here you can see it's defrauding the United States. What does defrauding mean? What does the United States mean? And what was the actual conduct that happened here, and does it apply? They say the Supreme Court gave us some rulings on it, and that political advocacy is not interference with a government function. They say to obstruct anything, they give us some actual definitions. Look at this one, it's from Webster's. To place an obstacle in or fill with obstacles or impediment. That is what obstruction means. More dictionary definitions. And they say the statute should be narrowly construed so that we protect First Amendment speech. The statute is way too overbroad. They say the courts routinely observe that 18 U.S. Code 371 is extremely broad, and they want you to narrow that. It requires narrow interpretation, a lot of technical stuff here. But for the reasons, this does not criminalize Trump's conduct. They say the prosecution creates a lot of vagueness problems. We need a narrow interpretation because if the law is too broad, it's going to criminalize a bunch of conduct that we don't want to criminalize. We want our laws to give people notice so that they know what the law is, and if they break it, there's responsibility for that. But if it's broad and it can mean anything to anybody, that leads to due process violations because you don't have proper notice about what's happening. So they say the narrow interpretation is necessary to avoid fatal vagueness problems. If the law is too vague, it's void for vagueness. If, as Jack Smith contends, any statement made in the course of advocating one's position on any hotly disputed political topic, in other words, if any politician says anything and that statement can constitute a conspiracy to, quote, defraud the United States, that is going to be just exploited. This interpretation, if adopted, would render the statute unconstitutionally vague because it would not provide fair notice of the conduct that is prohibited. And we know that that's a due process problem. People have to understand what the law is prohibited conduct. It has to be sufficiently definite so that ordinary people can understand what conduct is prohibited. You can't just pass arbitrary and discriminatory and forced laws. It's called void for vagueness, and it's a constitutional principle. Nobody's been prosecuted for something like this before, not in 234 years, but they just prosecute Trump. They say we should have more narrow interpretations, and as we continue on, we see other sections of the code, right? So that was kind of the same framework for one section. Same thing here. They say, what about the conspiracy charge? It should also be dismissed. Here, Jack Smith and the indictment, they take a statute directed at the destruction of records for accounting fraud cases, and they apply that statute to disputing the outcome of a presidential election. This takes that statutory language and it stretches it beyond any plausible mooring to its texts. We have another statute here. They say there is no evidence or anything even alleged of obstruction or impeding an official proceeding. What was the obstruction? They give us the definition for it and they interpret it, and they're trying to make the argument that Trump obstructed Congress and committed a felony, but they're just saying you don't actually allege what that conduct was. Similarly, Trump did not act corruptly, and they can't prove that statute. Corruptly has a key definition, and the corrupt purpose part of this cannot be satisfied by just pointing to lobbying or similar political activities. They say here, in this indictment, Trump engaged in, quote, a peaceful effort to convince members to raise objections. That's it. Any broader reading would make this entire statute unconstitutional, constitutionally untenable, and so we must get rid of it. The idea is that if you have some law that if you interpreted it one way, it breaks every everything, then the idea is you don't interpret it that way. And so they're saying here, Your Honor, like if we go this way on this case, it's going to be outside of alignment with all the other ways that this statute was used historically. And so they say here, as noted in Trump's other motion to dismiss based on constitutional grounds, as we already read through, President Trump and others, they do have a First Amendment right to state that the election was stolen, and they have the right to advocate for members of Congress and for other government officials to do something about it. Criminalizing that advocacy would raise grave constitutional concerns, to say the least, and therefore that should be rejected because it's going to break the whole structure. But it's Trump, and they're breaking glass in case of emergency. Further, they say other holdings support our claim, and they say this other count of the indictment should be dismissed as well. Trump did not have fair notice that he was interfering with a constitutionally protected right by seeking to examine and preserve election fraud challenges, and therefore this should be dismissed as well. They say no agreement between Trump and others to commit any unlawful act is identified. The indictment recognizes that Trump had the right to speak publicly about the election, also to raise concerns about fraud, to claim election victory, and to formally challenge the results. What they said was through lawful and appropriate means. But they say, as set forth in Trump's other motion, which we'll read in another segment, all of the indictment's factual allegations relating to Trump involve him lawfully carrying out his presidential duties. They were all protected by the First Amendment, as covered in other motions, and without the agreement to commit an unlawful act, without that element, there is no conspiracy, and so those charges should fail. They say, in 2020, no court decision had stated that contesting an election through lawful means, including by public statements, court challenges, alternate slates of electors, that any of that was unconstitutional or infringement of anyone's right to vote. To be sure, in fact, in previous presidential elections, the Supreme Court said that the individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as the means to implement the power to appoint the members of the college. Bush versus Gore. But the court did not consider whether either then Governor Bush or then VP Gore had individually infringed on any constitutional rights. In other words, by these guys challenging this, did they infringe upon your right as an American? They were using lawful means to advance their interests. Was Bush prosecuted? No. Was Gore prosecuted? No. The country was in chaos during that time. To the contrary, the court indicated that the parties had taken the appropriate route to resolve the dispute through the mechanisms. Historic precedent is also close and supports this concept, and courts have rejected prosecutions under this statute for issues that did not have clearly established federal constitutional protection. They give us some other cases here, and they also tell us that it doesn't allege specific intent, which I think is an important concept. Let's read it. It says Section 241 requires proof of specific intent to violate a constitutional rights. Because of this requirement, not every conspiracy affecting an individual's constitutional right is within the statute. So here, in this case, Jack Smith must show that President Trump specifically intended to interfere with someone's constitutional right to vote. It's got to be articulate and concrete. That's like, distinguish that from general intent, which is just you kind of intend the thing to happen, but it doesn't have to go to specific to someone's constitutional right to vote. And the prosecution has failed to allege Trump had any specific intent. Therefore, the count should be dismissed. They say they also must prove that Trump acted to accomplish a governmental purpose, and to convict Trump, they must prove that Trump took post-election actions to accomplish a governmental objective and not for any personal gain. Proving this, however, directly implicates Trump's presidential immunity. So accordingly, the prosecution will fail because it did not prove for a government objective, or it will fail because proving the government objective will confirm the charge is barred under presidential immunity. Either way, Trump is immune. And so therefore, count 4 is also deficient on its case. Man, that was a doozy. Seriously, serious stuff in there. And says this court should dismiss the indictment with prejudice. Signed again by the same two familiar faces here, your friends Todd Blanche and John F. Lauro, on behalf of Donald Trump. And so you can see here, I really like the structure on this. They went through every single statute one by one. We see them all here. Boom, 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 boom. 4 different charges, and they just broke them down. They take the statute, separate it out into its different subcomponents, and articulate why everyone fails every which way. And all of Trump's conduct, summarized, is protected. As the president, he's immune. He has the right to go and investigate and execute the duties of the law. The fact that they overlap with his political interests does not make it illegal. Other people have done it historically using these same mechanisms mechanisms they were in charge with a crime. And he's protected with free speech, and that, simply put, the statutes don't criminalize the conduct that is alleged. That is the whole basis of this filing. Motion to dismiss the indictment based on statutory grounds. So good stuff from Donald Trump and his defense team, and that is just getting warmed up. There's going to be a lot more on this case. And in our next segment, we'll come back in part 3 and we'll finish up with the motion to dismiss for selective and vindictive prosecution, saying Jack Smith is essentially illegally and unconstitutionally targeting Trump. And we'll also take a look at the motion to strike all of the inflammatory language out of the indictment. So be sure you're subscribed, my friends, because there's going to be a lot more on this case and all of the other Trump cases that we're covering here. Thank you for inviting somebody to come over, check out the channel, learn more about the mechanics behind what they are doing to the president, and we'll look forward to seeing you on the next one.